On the cloud. Okay, everybody. So thank you for joining. I believe this is our third meeting. My name is Tanika. I am the admin of the Dispute Fox unofficial group. It's unofficial because it is not an official Facebook group by the company. It's just something myself and a few other folks started who used the software. But I want to thank everyone for being here. If you registered, for showing up, thank you so much. Tonight we have a guest speaker of John, and I'm going to let him introduce himself momentarily. I just want to go over some housekeeping rules. I typically like to kind of hold the questions to the end. I'm going to let John speak and say, what he wants to say to us tonight about contract and compliance. And then after he's done, if you guys have any questions, you guys are free to have a conversation. The meeting is recorded, and once it's concluded, I will email this out to everyone that registered, and then it will go on my YouTube channel, which is at the Speak Fox Queen. Yeah, the Speak Fox Queen. I just made it, so I have to think of the name. But you guys will all get the link and stuff directly to your email. Okay. If you do have questions, if it starts to get like a little wonky with folks talking over top of each other, because we did have a lot of people registered, so I'm expecting more people to keep coming in. Just please, raise your hand and let John call on you. But if no one's hopping in, you're free to do so. Okay. All right, John, you want to go ahead and introduce yourself? And I was real fast. I just met John. So I just met John at CreditCon in person, and like he's super amazing. I attended your workshop there around contract and compliance, and I knew right off the bat you were super knowledgeable. You come highly recommended from other folks that I know. So yeah, you guys definitely want to listen to what he has to say.
Well, thank you so much. I appreciate the invitation. My name is John Diel. I call myself a contract specialist because I just draft contracts. I started my first credit repair back in like late 80s, early 90s, I think. And then I had a new family, so I needed to find a more regular income. So I got a job with the local government and did that for several years and continued to do credit repair on the side for a little bit. And then decided from the job that I was doing with the local government, I got into doing contracts and decided to go to school. And so then, I went to, get a law degree, but I did not get a law degree to be a lawyer or practice. So I do not have a bar and I'm not an attorney. I just draft contracts because I don't have to be an attorney to do that. So because of my interest in credit repair, when I left that job, I decided to get back into credit repair again. And technology had changed quite a bit. So obviously the chats and, the Facebook and everything. So I started to get involved in those and learned that a lot of credit repair organizations struggled with their contracts. And since I had the background in both, I thought I can help people, with their contracts and start offering it. And now it's like one of my specialties is state compliant credit repair agreements. So that's kind of how I got into it. Been doing it about 4 or 5 years now. I was lucky enough to go to CreditCon this year and meet a bunch of you and make a presentation. That was something I really enjoyed doing. I'd love to help people get into compliance and educate them about contracts. So I'm happy to answer any questions. Some things I'll say that may already answer some questions. One, there's about 40 different states that have state requirements for either their contracts or their information statements or disclosures, or both, right? So if you do more than one state, you should have a compliant agreement for that state. There's about 10 or 12 states that have the same information that's required because they're only CROA, and you can use those in any of those states. So another common question that's asked is, how do you, what do you charge and stuff like that. I don't tell people what to charge. I tell people, to look at what people are charging in the area that their customers are in, to kind of get what the competition's charging, to kind of get an idea of what's too low or too high. I can tell you, if you're charging $1,000 a month, obviously you're charging way too much. I'll also tell you that you never, ever, ever should take fees up front unless you
I
have
don't.
a trust account. What's that? I thought someone had a question there. So unless you have a trust or an escrow account that money is going into that's controlled by a third party, don't ever take fees up front. So that's another common question. So
I have a question real quick, John,
yes.
just to
Mhm.
kind of get you to elaborate more. And I know folks that ask that. Can you elaborate more when you say fees up front? Because I see people that do like this consultation fee, and I mean, I guess I see where they're going with it, right? Because you're kind of consulting them, but you know.
Yeah. My best advice is that you don't charge a consultation fee. I would include so depending on the state you're in, because some states have more strict requirements, but in some states, just like with CROA, you have to provide a service, right? The consultation alone is not typically enough to warrant a large, $200 fee, right? So it's, again, look at what the market is charging to give an idea of what you should be charging. So I think on average, you're looking at your first, your setup fee, you do an analysis of their credit report, you get their dispute letters ready. That's your first fee. That's going to be the highest fee. And some credit repair organizations charge $99, some charge $299. Once that first round is sent out, then you have your 30 to 45 days for the next round to go out. You'll review their credit report. You set out the next round of letters. Obviously, there's more things going on there, but just to make this easy, then you're sending out their what some people call a monthly fee. I call it a dispute round fee. That's typically $99 to $199, maybe a little bit more. You don't want to set up an automatic payment process, because what happens is, if you charge automatically before you've rendered a service, you just put yourself in a situation where you could potentially be in violation of charging before service is rendered. So it should be on a manual process, unless you're literally charging a month behind, to make sure that you never ever charge anybody before the services are rendered. That's a big thing that you don't want to get caught up in. Ignorance is not an affirmative defense. So if the regulator's investigating and they're looking at your payments and how their processes are working, and you charge before services are rendered, they're not going to accept, well, it was set up on automatic payments and it got through before I was able to send out the disputes. I don't think that's going to be something they're going to be giving you a pass on. So in this industry, the best thing you can do is do everything that keeps you in compliance and doesn't put you at risk of getting investigated, in my opinion. So that would be a best practice as far as my opinion.
And that's a great opinion. I agree. I don't have any counter arguments to that. I know
Yeah.
and we can do that too within Dispute Fox. And that's one of the reasons why I like them. Like, no shade to like any other competitors, but one of the things I know with Dispute Fox is that how it's set up, it is kind of set up to kind of help us be compliant. Like, for example, you can't auto charge. Other software they integrate with charge being bills be wages, they could just sign right up on their website. And with Dispute Fox,
Yeah.
that first initial invoice, it always has to be manual, right?
Okay, good.
Yeah, the first one always has to be manual. And then after you charge the manual one, then you can go in and set up the recurring billing. And I always recommend that people do bill in arrears. Of course, people can run their business how they want, so not
Right.
everyone bills in arrears, but
Yeah.
that's the what
Absolutely.
yeah.
Absolutely. And I'm not the credit repair police. I'm not looking
Yeah.
to, turn people in for,
Yeah,
however
me
they make their
too.
business. As long as you're not breaking criminal laws, I'm interested in helping you become compliant. I'm not interested in, getting the feds after you or the state after you or anything like that. But understand that if there's an investigation, your business can be shut down for several months, so you're not bringing in any revenue while that investigation is going on. And hopefully everything goes great, and you're cleared and but you've just lost all that revenue.
Mhm.
So that's why it's good to have, some other tips are make sure that your computer system that you're using, you have to log into your computer to get to the screen. It's not sitting there where I could sit down at your computer and open up everything and look in files that have personal information. You want to make sure it's very secure. You want to make sure that there's, you know, um, uh, virus software and stuff on your computer system that's protecting you and your clients and things like that. That's one thing they look for. Um, they're going to look at your contracts. They want to know what your contracts say. Make sure that it has the state language in there. They want to make sure that there's not language in your contract that's adverse to the client. They want to make sure that you're issuing the information statements or disclosures and you're maintaining those for, I think, I think the minimum is 2 years. There might be some states that have longer. I think Crow is 2 years where you have to maintain those files and all of the work that you've done for the clients. You have to maintain those. They'll be looking at that kind of thing. So, um, it's just good not to do the things that they're looking at, and putting yourself in that situation. But if you are, for random reasons, it can happen. It could be that you're doing everything right, but for some reason the state wants to investigate, so many credit repair organizations. They're going to come to your office unannounced and they're going to, start asking questions. I know this happened. It was at least 2 years ago. I think I had some clients from Texas send me an email saying, "Hey, do you know anything about the state regulators coming to credit repair offices and starting to ask questions?" I'm like, well, the first I think it was like three people that three of my clients had told me that they had heard from other CROs that the state was knocking on doors and just randomly doing audits, and they have a right to do that. So I haven't heard any recently, um, but if they're doing it, I'll hear about it eventually. So, and there are states that require you to have your, your contract reviewed every year. California is one of them.
And so is Maryland. I would say
Yep.
Maryland, and I didn't realize this until I became an entrepreneur that it's really hard to do business here.
Yeah.
But
Yeah.
everything, even for folks, so with credit repair, a lot of us also do taxes and stuff.
Mhm.
Like everything, we have to we actually have a license in Maryland. It's not like, oh, you don't need a no, in Maryland, we're one of the states we're required to have a license. You have to, like you said, review our documents and stuff every
Yep.
year. We have to keep reapplying. So like you have them, like you have the state and on top of whatever the federal government is regulating that we have to do. So
Yeah. Yeah. Ohio, you go through a pretty lengthy application process and they need to review your contract. I can't remember. I think Texas requires you to apply also, and you have to provide a copy of your contract. So there are some states that have, pretty strict regulations and applications, and then some states they don't require you to go through that whole process, but they do have specific laws that they want you to follow in their state and language that they want you to have in their agreement. So
yeah, particularly Georgia and I think it's North Carolina comes to mind with this.
South Carolina, I think,
North
is the one
Carolina,
you're talking about.
yeah, okay.
Yeah,
I
yeah.
know it's in the Carolinas, right?
Yeah, I would stay out of Georgia unless you're an attorney or one of the other, professions that they say that you can do it. They do not really allow credit repair in their state unless you are one of those. South Carolina is difficult because they only allow you to charge $50 a month, and you also have to get some kind of financial license or something that, for financial education or something like that. And then Oregon is another one that limits to $50 a month also. So those are the three states that I usually, don't recommend, just because I don't know how you can do business with $50 a month. It's going to cost you more in, your software and postage and things like that. Then you're pretty much going to be doing it for free. So if you have another, service that you provide on top of that, then maybe it's a good service to provide to bring in clients, but it's not really one to keep a business operating, in my opinion.
Right. I know it's just been us just going back and forth. I don't know if
That's right.
Yeah, I don't know if folks want to like come off and mute or raise their hand if you guys had specific questions for John that we didn't already cover. Don't all speak at once. Nobody. Because you guys
Yeah, I'm surprised. I'm usually get a lot of questions.
always asking me all the time.
Yeah.
Well, I know one thing that folks are probably would want to ask, and which is why I kind of reached out, and within the parameters that you are so comfortable speaking about, the three letters, right? TSR.
Yes.
You have any thoughts about that, and maybe best practices, not necessarily telling folks what to do, but maybe a best practice that you think is.
Yeah, I think that, the conventional wisdom with TSR is to basically get your client to sign an agreement before you get on the phone with them, especially if you have interstate clients. So if you have clients outside of the state, especially. And I think that's the direction that the government is going. One of my clients sent me the announcement from CRC and their two documents that they sent out. One of them was a little bit misleading. It said something about collecting fees, and it kind of looked like they were kind of promoting collecting fees up front. It was really confusing. But again, that's absolutely not. If you interpret it that way, please don't, because there's no state or federal law that allows you to take payments up front unless it's going into a trust account or an escrow account. But I think the advice that they're giving, is, I think it's good advice. I think the conventional wisdom, like I said, is make sure that your client has signed that agreement. I think also signed or understands and acknowledges the payment process, and how they're going to pay for the service, before you get on the phone with them. It's kind of a weird thing because I don't think there's any other businesses that require that that I can think of. But the laws aren't there for the convenience of the credit repair organization. They're for the convenience of the client, and to protect the client. So it doesn't make sense, but for that reason. So I do get asked a lot, what would you do? How would you set up your thing? And I'm like, I'm not a technical expert. The only basic way I can say it is figure out a way, either via chat or email, and electronically, that you can talk to that client and educate them about the process and then induce them into an agreement before you talk to them on the phone. If you're induce them into an agreement on the phone, then you've just, potentially violated the TSR. I mean, there's more to it than that. That's very basic description. Some people I've talked to said, hey, if they can talk, you could talk to them on the phone. You just can't, you can just talk to them in a very broad, broad description about your services. You don't make any guarantees. You don't get them to sign a contract. But, I would feel more comfortable if, as many people as you're talking to, you don't want to accidentally say something that could get you into trouble. So if you treat every customer that way, and you know, bring them on board that same way, then you lower your risk of being potentially in violation of TSR.
Right. And I know when I don't know because people are like, oh, it's not a new rule, right? When the news
Yeah,
came out, and it's not that it's like was a new rule because for most of us, we all know TSR. I think
yeah,
the way that this company interpreted it and the documents that they put out, I think which was confusing because you
yeah,
know, I've seen a lot of comments about removing phone numbers and off the website and you know making it like a self checkout type of sort of option without you ever talking to them. So I know it's been a lot of you know conversations around that, and I'm not an expert you know and that's in this as well. I know at least for my processes, one of the things I do appreciate with the Spree Fox is that it does have built-in automations, right? So you
yeah,
do have we do have like a little bit more flexibility for folks who maybe do want to have like a what we would call maybe like a offhand onboarding process. You know what I mean? Like they have an app so you can talk to folks on
yes.
it and stuff of that nature to try to get around that. But you know, like I feel like it's one of the things, like depending on who you talk to. Because then I also heard somebody else say, well, you can't really do email either because the federal government owns the internet. So like, I don't know. Like
No, that what you can't do is use Zoom,
Zoom.
right? So
Okay.
Zoom
Yeah.
or telephone, they look at it the same way. Email you can use,
Okay.
chat you can use, text you can use.
Okay. Yeah, I
Um,
saw somebody said text is a phone, so text would trigger TSR. And I was like, well, that's not how I read it, but
yeah, and I mean, I guess maybe if you do it over Facebook chat, maybe that's probably better.
yeah.
And they may be right if you're doing, text on a phone is over the phone, so they could be right. Um, but you could do it through Facebook Messenger or put a chat thing on your website where people can just send a question to you right away and someone can answer it or email. But for a long time, I was telling my clients to take your phone number off your website so that way you don't get put in the position that, every day you're going to get phone calls and it's like you're going to have to sit there and have this conversation and think, well, I don't want to answer something or I got to be careful not to say something. It's like, just don't put yourself in that position, make it easier for you to avoid that than having to think about it in the back of your head all the time. Because there's nothing worse than going, wow, I just had that conversation. Did I violate TSR? It's like ridiculous. I know, but but people are getting more tech savvy and they're getting more comfortable with it. And I don't think it's as hard as people are putting, thinking it's going to be, because a lot of people would prefer to probably do it that way than you talk to them on the phone or see their face because they're embarrassed about the fact that they need credit repair or something like that. So maybe, you know, um, maybe you'll that target audience, will be a little bit easier to bring on board that way because they're used to it with other things. I mean, I was thinking to myself about kind of things where I'd be looking for something online and you go in there and then you just have this, you order stuff and you never even talk to anybody. So we all do it. We go on Amazon and order stuff all the time. We never talk to anybody. you know so people buy billions of dollars of stuff from Amazon and never talk to a soul. So it's different because that's products and this is a service, but people are used to doing it, so it's not like it's foreign to everybody, right? So
Gotta have good marketing, y'all. Y'all hear that?
yes, yes,
Mhm.
yes,
It's like
yeah,
marketing. Uh,
yeah. And I've had some clients say that they have a process where they set it up where they can review somebody's credit report for the client. Before they even enter an agreement, they have them send the credit report to them, and then they videotape themselves going over the credit report for the client. And say these are the things I identify in the credit report, and then they send it back to them and then explain in the thing about if you want our services or what we provide, and this is the steps you have to take. And then you go to this website and do this. So
yeah, I've been doing that since CreditCon.
Yeah, there you go. There you go.
So if you guys so I put all the videos I put on my YouTube channel, but yeah, so I got that idea from somebody else. So it's not original. I'm not taking credit, but I use Loom. I recorded. I
Mhm.
use the credit analysis as a free lead magnet. And for me, and I'm probably giving too much sauce, but what I did, and I don't know if I should say this on the recording, but I just use Upside Nation, right? Because I know like some folks like to charge $25 to the client. So instead of charging a client, I just use Upside Nation, right? They give you $25 for that $1 sign up, right? So I've been doing that since CreditCon. So I'm like,
Huh?
so what I do is I'm like, I do require them to order that credit report, because I'm like, well, there's no need for us to even do a consultation, do anything if you don't even want to spend $1, right?
Yeah.
And I
Yeah.
have my automation set up through Dispute Fox where they come in as a lead, they fill out the form, they send me their login credentials, I record the video, and on their credit audit, we're able to go in and edit it, right? So I edited mine to say, hey, not call me, but hey, here's how to go on the website and sign up if you want to
Perfect.
sign up. For me, it kind of works out because I still have my day job. I tell everybody this, like I'm a mom, I still have my day job. So for me, to your point, John, like I didn't want people cold calling me anyway. Because
Yeah.
then that could come off as bad customer service if we're busy, right? Like, oh, your
Hmm.
company never answers the phone. Well, I'm at work from 9 to 5, so I can't, I
Yeah.
can't answer my phone anyway. So it kind of works out. But for other folks who've been in the business for a long time, I can see how change is hard, right? When you're trying to like
Hmm.
navigate all this stuff.
Yes.
Yeah, it does look like like they're trying to put small businesses out of business. It's just like we cross. I mean, I only been doing it for 3 years. In the 3 years, like every time you turn around, to me, it seems like it's something new that's coming down that they want us to do or not do. And I see Tisha has her hand up.
Hello, hello.
Hi,
Um,
Tisha.
hi, Mr. John. Hi, Tanika. Thank you guys for all of the valuable information. I had two questions, but John, you just answered one, in which Tanika, you've mentioned before about how pretty much the consultation process of recording the videos, etc. I'm in the process of making some changes, and so I will consider that. My other question was when Mr. John, you were talking about the contracts. Couple years ago, when I initially started out 5 years ago, everything in the contracts, like as the disclosures and all of that, was one contract. But I was with a different software company at the time, and so I reached out to an attorney and she redid my contracts, and she had all those things individualized. And I just want to touch bases on, is it necessary for them to be individualized contracts for like specific parts of the contract, or is it okay to have everything together?
So, um, depends on what you mean. So the disclosures have to be separate, right? So you should have a CROA disclosure and a state disclosure, and
Right,
then your contract,
right.
right? So the other thing is that if you use a power of attorney, and I have no opinion on that, whether you should or shouldn't, or whether one's better, using it is better than not, I don't know. But if you have a power of attorney, that has also got to be a separate agreement because your client has to sign that and a notary has to also sign it. So that has to be a separate from your agreement. But you should have a clause in your agreement that speaks to it and says that, the client will be signing exercise in a power of attorney. Also, if you have a credit card authorization form, that should be a separate form, but there should be a clause in your agreement that speaks to it, that says that you're going to be signing a, credit card authorization form. There is, a software that provides a contract in their software, which is not a compliant contract, nor is it an enforceable contract. And it also has a power of attorney language in the contract. It doesn't make sense to me. But I've had clients that actually use that as their contract, and luckily they came to me and I was able to, you know, educate them about that contract or that document and draft them a compliant, state compliant enforceable agreement. So You know, so it all just depends on how your attorney separated out the documents, and you don't want the disclosures in the actual agreement, because some states require you to present those to your client prior to the agreement so that they have those disclosures to read and execute before the contract. So it just depends on how your state law is set up to determine how that, you know, how you do that sign up process with your client.
Okay, thank you.
Yeah, absolutely.
And just to piggyback off of that, I have mine separated out. Now, I asked the Spruce Fox this too, because John, you brought up a good point about how without agreements, they have to sign certain stuff first. So if you guys will notice with the Spruce Fox, when you are adding stuff in there, like when it goes to the client, it kind of goes in the order that you added the agreements. Because in the Spruce Fox, you can add multiple agreements. So what I had to do was, again, it's a pro tip because we don't have the ability to do it ourselves. If you want your stuff to go out in a certain order to them, put in a support ticket and they will go in and reorganize your contracts for you so that when a client comes into the portal, they're seeing whatever it is you want them to see first in whatever order. Okay, because I do have my disclosures out. I have my Maryland State stuff out. John, I added a ton of stuff from, I need to give it to you in another time, but I added a bunch of stuff that you mentioned about arbitration. I didn't even have nothing about arbitration and stuff in my agreement. But yeah, I put that in there, some other stuff, but I always have like a chargeback. I had like an unpaid invoice. I do have a, so my chargeback, basically how mine is, disclosures are separate. My company internal policies is one agreement. And then after they sign that, I have the arbitration, I have the bank card authorization form. And because I'm super extra, I have a release of information. So if they come in with an affiliate, I have them sign it, saying I have permission to share their personal business with the affiliate, because the affiliate gets a copy of their progress report. Oh, and I have because I'm just extra, y'all. I have a what you call it, maybe like a permission to share their results. Did that make sense? Because
Yeah,
they have like a feature now where when we re-import that credit report, they automatically create like a Canva template with their whole, I mean, you can edit the name off, but it automatically has the client's name, like their first name and initial and all that stuff on there just for us to reshare for marketing. So I went and created like, a permission to share your results, right?
yeah,
So I put that in there too.
yeah, yeah. I have a general paragraph about social media. But yeah, you always want to have a dispute resolution clause in your agreement in case there's an alleged breach, either by the client or the client's accusing you of breaching the agreement. And some people want to go to court, and that's fine. So it'll be a choice of forum. Usually it's district court, in the jurisdiction that they're in. But a better one, I think, is arbitration, binding arbitration, because it's private. It's not public. It's quicker. It's cheaper. And you're dealing with a small amount of money, so I think it's more efficient and less formal. But you should have a dispute resolution clause in your agreement. If you don't, then if the client decides that you breached the agreement, they can just sue you in court, because you don't have it specified in your agreement that they've agreed to arbitration. So, yeah.
Yeah, it was gold stuff there.
Yeah. Now, I know that all of you probably don't have to deal with that because you're such good, business owners, and you listen to your clients, and if your client wants a refund, you probably just give it to them. You don't argue with them about it. I mean, nobody wants to have to deal with that. I always recommend that the best course of action, if your client's not happy, just give them their money back and be done with it. It's not worth going through that process, and it's also not worth getting your name spread around the internet, because they disagreed with the decision, and you decided that I did the work, I'm keeping the money, instead of giving it to them, and then they just badmouth you all over the place, and that's just not worth it. So it's just my opinion.
Yeah, no, that's true. That's a good point. Yeah, when in doubt, just give them the money back. But
Yeah.
I always like to hope for the best, kind of plan for the worst. So
Yes.
I have like these different things. Um,
Yeah, and there's nothing wrong with that.
in there.
It's good to have, different things. And, it's good to have your policies in a separate document that kind of spells out, the expectations. There's expectations you want in the agreement, that there's obligations that are for you to your client and also for your client to you. Like, they're not going to apply for credit during the course of this agreement because, you don't want them making, adding more, you know, uh, potential declining, their credit score and stuff by applying for stuff. You don't want them to have more inquiries on their credit, so you're saying, I don't want you to apply for credit. You're not going to lie to me. I'm going to take everything you say at your word, and you promise not to lie to me or mislead me because, you're acting on behalf of your client. And so, you just want them to say that. So there's certain things you want in the agreement that, that your client is obligated to follow. How soon, if you don't use a power of attorney, you want them to give you the documents they receive in the mail within a certain amount of time, right? So they don't hang on to them for a month, so you want them in 5 or 10 days after they receive them. So you want to put that in the agreement. Also, if you have your client sign up for credit monitoring and they have to pay for it, right? Then that has to be in your agreement, because if it's not, it's considered stacking. Stacking's illegal. What that means is you have a hidden fee, meaning that, in order to carry out this agreement, one of the things they have to do is get credit monitoring, but they have to pay for it, but it's not in your agreement, right? And they sign this agreement. And they're like, oh, by the way, you got to sign up for this. So that has to be out there because it's a fee that they're going to be paying.
Oh wow, that's a good point. And I don't know, maybe I should have went to law school too, but I didn't. I went a different route. But to that point, I went in and I did add I don't know if you saw my comment in the chat. So Dispute Fox, they did integrate a POA system for us.
Yes, that's awesome. Yeah.
And so I went in, it's 1995. It's integrated. It's a live rep, so the email goes out, like once you trigger it, the email goes out to them and they do the verification or whatever with the live rep, then it comes back to us. So because I knew that was an additional charge and I'm not paying for it, I did I did went in and edit my fee section of the contract to put the 1995 in there.
Yes.
But it's optional, right? So for me, I made it optional because they do have in Dispute, they have the option to either pay the $20 to do it, or we could let them download it, right? And they could take it to their own notary because it's only $5 if they do it on their own. But I made sure I put that language in there, like, hey, you have X amount of days to either print it off yourself and do it and send it to us. Otherwise, you're going to get this 1995 charge, right? Because we need this run a business or whatever. So yeah, that's a good point. I just want to call that because most of these people in here used to Dispute Fox. So if you saying something, I'm gonna like kind of prompt them like, oh yeah, make sure you guys put that in there. Because
that's important.
It is $20. So to use it.
It's important. If there's something that they're required to do and it's going to cost them money, you want to have it in the agreement so they can't come back and say they weren't told, that they had to pay this fee. And if you look at the state and the federal laws, it says in there that you have to give an estimate of the total fee for the life of the agreement. Fees, right? So that includes, what they're being charged for the credit repair, what they're being charged for credit monitoring, if they're being charged for the POA, things like that. And if you're not sure, just include it in there. That way you're not going to have to worry about, I forgot to put something in there I should have,
Yeah.
So.
And I hate to keep that's because I just love the Dispute Fox because they just like I feel like the Dispute Fox like a year's way ahead of their competitors. And I think and what I like about them is that they listen. So a lot of people who have way years, history in this, they come in and they make recommendations to them and they implement it, right? So to your point about I didn't even know that until I seen that data fill in there. So we have that data fill in there where you could total up how much it's going to cost for the credit repair in your agreement. they have a space where you would put the initial amount plus their monthly amount times X or plus X, and you decide whatever X is. So if your people coming in and you say, oh, well, this is a 6-month agreement or a 12-month agreement, you put that in for X in the agreement. When it generates, it automatically totals up what the expected cost is.
Yeah, that's great.
That is awesome, right? I'm
That
like,
is. That is.
every time I get a brief, I'm like, look, just swipe the card because y'all it's just like way ahead. Like and I know that had to come from one of us that was doing that, right? That was like, hey, we need this in here because Crow or whoever said we have to have that in there, right? The same thing with client agreement, where some states is 3 days, some states is 5 days. Yep. So before they made the update, I just used to go in and say, oh, you have 3 days to cancel. It's 3 days in Maryland, right? Or you have other states might be 5 days, right? But Dispute Fox, instead of just saying 3 days, because most people like, what do you mean 3 days? Is it 3 business days, whatever? So Dispute Fox, they got a data tab or a data variable where you could go in and it will tell them the exact date. You put 3 days, it does like the math. Like if this 3 days from whatever the date they sign it, it actually populates the date. And you just write, at midnight on this date or whatever. So it actually populates. So again, like if you guys are not using it, like just go in there. And I tell everybody, like if you're shopping software, whatever, just go in there and see what's going to help you run your business, what's going to help you. At this point, the priority is be compliant, right? To have the stuff to make our job easier so that we're not like running around trying to pull all this different stuff, because they have so much in there, from not being able to auto bill the first one, putting the power of attorney in, putting the dates in, putting the data fields to calculate the total cost of the credit repair. Like all that stuff is already in there. You just have to go in there and put it in your agreement.
Yeah. Yeah, exactly. Yeah, that's good that they're that responsive, because
they are.
And depending on the state, some say 3 days, some say 3 working days, some say 3 business days. So, those could mean different things, right? So, and then some are 5 days. So, I have a client that has several states, and they just put 5 days on all of them. That way they didn't have to
cover all that basic.
Like I'll just do 5 days because I'm, 3 days is the requirement. I'm getting them 5 days, so that way they're all the same. I don't have to deal with it, and that's fine, because you can't go less than what they require, right? So, but they're not going to ding you for going, longer. So.
Yeah. So can you speak to that? Like what would be a best practice? I don't take folks out of Maryland. I feel like Maryland is enough. I'm like, if I just need 100 people, that's all I need. I don't need to be, I just need 100 clients. It's like, how many people in Maryland? But for folks who do multi-state, like, do you recommend they have a separate agreement for each state, or maybe just one agreement and disclose it? Okay.
I recommend a separate agreement for each state, because each state has different requirements. They have different disclosures requirements. Some have different contract requirements. So you want to make sure that you have, an easy way to say it is, in credit repair, the statute follows the client, right? So if you have a client in another state, you have to follow that state's laws, right? So I'm in Washington, client in Washington, we follow Washington laws, and federal, of course. If you're in California, that client would have to have a California specific client agreement for the state of California, because Washington state laws make no difference to the client in California. So it is highly recommended that you have a state specific agreement for each state clients that you serve. And I should tell you, I do draft contracts. I also review contracts. So if someone has an existing contract they want reviewed, I review those contracts and give them recommendations, and I'll draft them and edit them if they want, and so I do charge for that service. But I can't hear you. I think you're on mute.
There you go. I'm just agreeing with you. Like, yeah, and you said, when you said, are you charged for the service? I said, of course, like, as you should. Well, let me ask you this too, because I know we're almost coming up on time. So
Yeah.
this I don't before, because do anybody have any questions? Because then I'm just going to ask all my questions, and I don't mind. So, what about for DIY, right? So this is where I probably need the help at, because for my done for you service, I kind of listen to you, Dustin, and other groups, and I just kind of put my own stuff together. Um, so I'm definitely going to get up with you to like reviewing what I have.
Sure.
But with the DIY, so I get a lot of questions about that, and I'm like, I don't really know, because from what I'm hearing, I'm like, even if we're doing DIY, it's still kind of like we may still be responsible. So I switched from DIY, and I kind of what I call it now like a hybrid model, where like I create the letters, and they have portal access, right? But I create the letter, and they have to mail them out, right? So I really like that's going to be like a little bit different with the permissions and stuff. And I don't know. I have something in my software, but I'm pretty sure I don't know if it's the right thing, because it's like if I'm creating the letters and they're mailing them out, like, are they giving me authorization? Because I don't need authorization to communicate with them. I don't know with the companies. I don't know, but I know a lot of folks are shifting to DIY. So I don't know if you want to just
Yeah.
real quick talk about, do we need like a separate DIY contract, or we're doing like how I'm doing like a hybrid thing?
Yeah,
Like
I would
how
recommend a separate agreement for DIY. And DIY means do it yourself. So if you do any steps for the client at all, that is
Mhm.
not considered DIY. So
Right.
if you do anything for the client, that's credit repair, that you're conducting credit repair. So
So it doesn't matter if they're mailing it out themselves. I don't necessarily have to have like a hybrid. I call it a hybrid agreement.
right,
It
right.
could be the
What it
same thing.
means is DIY means
Mhm.
you give them the tools to
Right.
look at their contract or look at their credit report and know what to look for, and then how to draft a dispute letter, and they draft it and they send it. You don't have anything to do with it. So it's totally like an ebook, or it's on a webinar or something. But you are not doing any of the work. You're just telling them how to do it, and it's all recorded. It's not live. You're not they don't call you and talk to you. You don't email them back and forth. It's all independent. That's DIY. And yeah, I do recommend a DIY agreement, because you want to make sure that the client understands that they are on their own. There are no guarantees. They have to follow the steps, blah, blah, blah. If you have a process that is different than that, but also different than your credit repair, you may or may not be able to include it in your credit repair agreement. It just depends on what the service is, right?
Oh, nice. Yeah, I appreciate that. I've been working my
Yeah.
brain, and I was like, I'm gonna get somebody to look over the hybrid stuff, because I get that too. Like, I just thought it was a good idea to offer something like a less cost, because the
Mhm.
economy, and
Yeah.
and I know I'm not the only business, or like a lot of people like credit repair, even though they need it, is the last thing on their mind. So offering something for folks who, you know, don't necessarily know the laws or know things, but they still want to work on themselves, at a lesser cost. But
Yeah.
it sounds like you're leaning, because I'm creating it, it would technically still be the same agreement.
It'd be credit repair still. Yeah,
Okay.
because you're creating the dispute letters. They have to do everything on their own for excuse me, for it to be considered DIY.
Okay.
Yeah. If you're doing anything, if you're touching anything, it's considered credit repair, and the statutes will apply.
Okay. That's good. See,
Yeah.
that's why I'm staying in my state, because too, I don't
Yeah.
have time to be like this state say 3 days, 5 days, 4 days.
Yeah. Now DIY though, you can have clients all over the country DIY, because
Yeah.
they're all doing it on their own, and you don't touch anything, and they're just signing up for a webinar or buying an ebook and doing it. That's perfectly fine. But once you get involved, then it goes back to credit repair, state statutes, CROA, all that apply.
Makes sense. Okay.
Yeah.
For some reason, could have been under the impression that we could be off the hook as we're not mailing the letters, but no.
No.
Okay.
Nope.
T's hand is up again. Go ahead, Peter.
So in chiming in on this DIY conversation, um, so if we have, just say we have, whereas they sign up for the DIY, but like it's, I have a different platform that I use, and I'm not doing it. They do everything. They choose the letters, print the letters, everything. But they're paying for access to that platform. Is that considered me including me in any kind of way of credit repair?
Well, and not unless you're doing something. If you, so there's a software. So I know of a software that you can do the, manage your clients and do your credit repair, and then it also allows for you to sign up DIY clients in that same software, and it's all DIY. You don't do anything. You just
Okay.
mark them as a DIY, and then they have access to all the DIY
What?
functionality, but you're not doing anything.
Okay, I was
Okay?
asking
So you
because if
charge
they're
them.
yeah, they
Yeah.
can pay me to utilize the software, but just as long as I'm not touching
Yep.
anything as it relates to them in the credit
Yep.
repair process. Okay.
Right. Yep. Yeah. Yeah, that's perfectly fine because they're just paying for the access of the dispute letters and stuff like that, and you're not doing anything.
Okay.
Yeah,
Thank you.
of course.
Yes, this has been great. Anyone else on the call to have any final questions for John before we kind of close out? I'm thinking myself. I feel like I asked a lot. I feel like we covered a lot. Um, so John, like, if no one else, did you have anything else you want to close out with, and maybe tell folks that you guys want to say, tell folks how we could get a hold of you if folks want to either get that contract drafted or have that current contract reviewed?
Yeah,
What's
I
up?
just put my email address in the chat there, so if anybody wants to reach out and ask about contracts,
Mhm.
again, I draft contracts and I also review existing contracts. Um, so happy to do either one of those. If you have questions about, specific things, I'm happy to answer those. Um, so I don't, what is the software that you mentioned? I'm trying to remember the name of the software. Um,
Yeah, it's a
yeah,
tons of software that does DUI. And we
yeah,
can talk up too more about that offline, but it's
yeah.
tons because I have a DIY too. Because initially I had one that was white labeled. But again, I never really marketed it right because it was like I kept getting mixed stories, like, oh, if you do DIY, it still falls on the crow. And I'm like, wow. So now when I went to CreditCon, I was at the vendors and I saw another company, I think Credit Score IQ. They're still new with that thing, but I'm just gonna refer because I want something that's different that don't have my logo. So no confusion, no anything. Just a totally separate. Hey, here's my partner. If you want to do DIY, I think it's $30 a month, and then I get a residual off of that, and that's what I'll use for my DIY folks and people out of state. But it's tons of DIY.
Yeah.
Yeah, that's the one I use too, Marsha, for my one that I haven't even used. And I'm paying for the domain. It just and GoDaddy just reminded me too that it's about to renew, so I should cancel it. Because at this point, like, I'm not going to use it because even though John, you just said like as long as we're not doing anything, but clients can still get confused, right? And if they're not seeing results, I don't want them to come back to me and be like, oh, yeah, it didn't work. I'm not, I want them to put it on the partner. So.
Yeah, and that's why I say, there should be some type of agreement, either with the
Yeah.
company that is hosting the DIY or with you with the client, so the client understands that they're on their own
Mm-hmm.
and that that you have no responsibility whatsoever. You offer this for them to do at their leisure. They have to do their own, research and blah blah blah. So that then that way they know, and they sign that agreement saying that you have no responsibility whatsoever, basically, and that there is no guarantee that they'll remove one item. It's all do it yourself.
Right.
So, yeah.
Right. All right, guys. Well, this has been great. Any last call? Anybody has any questions in the chat? If you don't want to come off mute, you could drop them in the chat. But John, I know, so remember this is recorded, so this is going to be on YouTube, so they're not going to see the chat, but this is your actual Facebook name, right? So they can reach out to you,
Yep,
social media, if they don't see
Yep.
your email.
absolutely.
All right. All right. Well, if that's it, I want to thank everyone for joining. I'm going